attorney, wills, and guardianship. I believe Judge Frazier touched on guardianship quite a bit earlier, but it's important to know what these different legal documents and processes look like, especially if you've never had an experience with them before or don't have the documents yourselves. So under the broad umbrella of estate planning, most of us have heard about a will or a power of attorney, but it's a little bit flexible of a term because there can also be things like living wills, advanced directives, funeral planning declarations, all sorts of documents can fall under the umbrella of estate planning. But estate planning helps answer questions like who can make financial decisions for me if I'm not able to, who can make medical treatment decisions for me, what happens to my property or assets after I pass away, and if I don't have documents in place, what processes does my family have to go through? But without estate planning, as Judge Frazier mentioned, there is a court process that has to happen in guardianship if you're incapacitated and cannot make choices on your own. There can also be state law interference with what happens to your property after you pass away. If you don't decide, the government does. And family conflict can arise, as I'm sure we've all heard about. Someone has had unclear documents, or maybe they don't have estate planning documents at all, and their family doesn't know what to do. Over the last 2 years, there have been 2 major studies released on estate planning in America. About half of people die without estate planning documents in place at all. The number one reason that people don't have estate planning documents is procrastination. The response to the survey, where people actually got to pick why they didn't have estate planning documents, was, I just haven't gotten around to it. That tells me that to those people, it is a priority in the back of their mind, but they haven't taken action to have anything completed. Some other shocking statistics include, if you do have estate planning documents, under a quarter of people have updated those documents since they signed them. So chances are your life has changed, your circumstances have changed, and those documents need to be updated. They live with you, so you need to update them to reflect your situation. And about 1 in 4 people say that they would not know what has to happen if a loved one passed away. So without clear instructions from you in your estate planning documents, your family might not know what to do with your assets, your stuff, what your wishes were. So it's important to get these documents in place. A will is a legal document that says what happens to your stuff, whether that be real estate, your personal property, your money, after you pass away. But I like to say it's a set of instructions for the probate court on what you want to happen with those things. If you do not have a will, Kentucky decides what happens with your stuff, where assets pass, who inherits from you. Like I said, if you don't decide, there are laws in place that say where things go. And something that I'd like to focus on too is a will does not avoid a court process after you pass away. It's merely a set of instructions. Trusts can avoid the need for that court process when you pass away. A power of attorney is a different document, and this document is like a permission slip. It gives someone else the authority to act on your behalf. That can be for medical decisions, it can be for financial decisions, it can be for anything you have to make a decision on. But that power of attorney document has to say specifically what you authorize the other person to do. In many cases, it's used for convenience. For example, I don't think that estate planning is just for elderly folks. I myself have estate planning documents. I have a power of attorney. My husband and I use our powers of attorney. Like if one of us can't get off of work and we had to sign a legal document, my husband would sign on my behalf. I've authorized him to do that. And same goes for him. If he couldn't get out of work and I had to sign something for him, I have power of attorney to do so. Powers of attorney can also be general or limited. They can be durable or non-durable. So what do all of these terms mean? A non-durable power of attorney ends if you become incapacitated. I have never drafted one of these. I do not recommend them to anybody. The non-durable power of attorney says, hey, I want this other person to act for me so long as I have the ability to make my own decisions. But if I lose that ability, I want their authorization to end. How does that make sense? The whole purpose of having a power of attorney is so that if you cannot make choices for yourself, there's already somebody that you trust who's able to. Financial power of attorney refers to giving someone authorization to make financial choices or money decisions for you. This can be like accessing bank accounts, accessing financial information, and signing documents related to finances. A durable power of attorney, every single power of attorney I've ever prepared has been durable. This means that if you cannot make choices for yourself, then the power of attorney still stays in place. Someone is already authorized to make choices for you in accordance with your wishes. A healthcare power of attorney decides medical decisions. So this could be consenting to treatment, medication choices, what doctor you use, things like that. Often, I prepare powers of attorney that are both medical and financial, so long as you have the same person listed as both. That way you're only keeping up with one document. You don't have to keep track of two. A POA can act on your behalf with whatever authority you give them. They cannot act beyond that, but they can sign documents for you, access bank accounts, make medical decisions, but they cannot override your will or your trust if you have one. They cannot act beyond those powers that you've granted to them. They cannot make decisions after you pass away. I often tell clients, a POA dies with you. It is no longer in effect when you pass away. I hear all the time folks will come in and say, oh, I had power of attorney over my mom or my dad, and now the bank account's frozen. What do I do? There's not really anything you can do because you don't have power of attorney anymore. A power of attorney cannot place you into a nursing home or a facility against your wishes. They do not have control over your person. They only have the authority that you granted to them. The power of attorney is the most important estate planning document that you can have because it protects you while you're around, while you're alive and here. I still think you need a will though, because the will can come into play after you pass away. You need to do both documents while you have sound decision making and know who you trust with your own choices, with your stuff, with your property. Now let's talk about guardianship. Admittedly, when I was asked to do this presentation, I was confused as to why I was talking about guardianship too, because it's not an estate planning document, but it is a process that becomes necessary if you don't have estate planning documents. So let's say, and Judge Frazier touched on this too, but let's say you can no longer make sound or safe choices for yourself. In that case, guardianship is the only way that a family member can help. If you don't have a power of attorney, nobody else has control over you. So this court process becomes required for a family member to make those choices. And guardianship, I'm using as a blanket term to refer to that whole process, but guardianship refers to a person who is in need of someone to make personal or medical decisions, whereas conservatorship refers to financial and legal decisions. Fiduciary refers to both. It's just the person that the court has appointed to make those choices for you. Guardianship is not always necessary. It can be necessary if someone has dementia or memory loss, if they can't make sound choices because of a serious illness, injury, or accident, or are on medication that makes it so they're unable to do. But just because you have a dementia diagnosis or someone gets diagnosed with mild cognitive impairment or decline does not mean that guardianship is required. That just means that if it gets so bad where you're not making sound decisions for yourself, you're not capable of doing so, then the court has to get involved if you don't have a power of attorney. I also often hear that clients will say, hey, I went to the hospital with my loved one or went to the bank with my loved one and they said that my power of attorney isn't good enough. So guardianship is better, right? No, guardianship is not stronger or better than a power of attorney. Guardianship is a very serious process. It involves the loss of someone's constitutional rights in some cases. So it is a last resort if you don't have proper documents in place. But because of its seriousness, we want to avoid it, and we can, by having a power of attorney and other estate planning documents in place. Some of the key differences between guardianship and power of attorney is that guardianship is a court order for someone to act on your behalf. A power of attorney, you get to decide. You create it privately with the help of an attorney. The judge also makes a decision on who is making your choices. Whereas with a power of attorney, you decide, not the judge, not a court, not anybody else. Guardianship can also be expensive and time-consuming. But if there is any sort of dispute, whether it be as to how incapacitated somebody is, or to whom to grant guardianship or conservatorship among family members, that can often drag out and become expensive for everybody involved. It also involves multiple parties. We're talking about the court, the county attorney, all the individuals who have to examine the person who might be in need of guardianship or conservatorship. With a power of attorney, it's just you signing your document and the person that you've granted authority to. Guardianship also requires all next of kin to be notified. So if maybe you don't have a great relationship with someone that has to be notified, it can often bring family members into the mix that maybe you didn't want involved in your choices or wouldn't want involved in your planning. Whereas in a power of attorney, no one has to get notified, but you should make the person that you're appointing aware that you've given this authorization to them. Pre-planning for these things is essential because you can protect your family's financial future, preserve your assets, make sure you pass them on to who you want to have them. You can avoid being forced into crisis decisions or a court process that is entirely avoidable, and ensure your wishes are followed. You are acting under your own control when you sign estate planning documents. You can also provide clarity to your family members on what you want to happen after you pass away. Without that clarity, it's ripe for conflict or people's feelings getting hurt, or maybe folks thinking that you're being unfair when your wishes aren't clearly stated. So I wanted to reserve sufficient time for questions because I knew that I covered a lot in a little amount of time. So are there questions or comments that you all have about any of these?
Yes, you mentioned that your POA could not get into your bank account. However, if I do have a POA, how could she get into my bank account? I'm single, my parents are deceased. I have basically no family.
Okay, so after you pass away, if there's only a power of attorney in place, yes, you're absolutely right. That power of attorney is no longer valid, so your bank account would be frozen. But there are other options as to how your bank account passes, if you've got a beneficiary listed, if you utilize trusts, things like that can help. But a will would say where you want things to go after you pass away. Doesn't have anything to do with accessing the bank account, because remember, if you only have a will, that is just an instruction to the court on what you want to happen. Someone would still have to go through that court process. So to avoid that, you would need some sort of trust planning or beneficiary listed on the account. Yes.
Can I piggyback off of that? Another way that we'll do this is if you're trusting the person enough to be your power of attorney, we will also assume that you trust them enough to be a joint owner on an account. So we have opened a joint account before, not moved all the assets there, but have enough that those immediate cash needs can be put in that joint account so that the other surviving person could still access the joint account.
There are many situations, though, while I understand that for immediate funeral expenses and things like that, there are situations in which you would not want to make that account jointly owned.
Correct.
Simply because if you require nursing home care in the future or something like that, making a joint owner on the bank account can be risky in terms of getting coverage for that nursing home care or paying for it. Are there other questions? Yes.
Is it more advisable to have an elder attorney for your trust, or can you use your trusted lawyer you've used for years that already drawn up your wills and your power of attorneys and those documents?
That's a really good question. I recommend you see an elder law attorney just because elder law attorneys are specifically researching and knowledgeable about the issues that you could face as you age. So let's say you had a trust from 20 years ago that your general practitioner attorney that you've used for pretty much everything did. I'm not necessarily saying that planning is bad, but a general practitioner doesn't have the specific knowledge about long-term care, Medicaid, maybe incapacity or something like that you may face. So building a relationship with an elder law attorney can be helpful because we know what to look for.
Let me rephrase the question then. If you have, everything's going to be left to one person, would I still need an elder attorney? There's just one beneficiary on my assets.
I would say yes, simply because, and I'm an only child myself, my parents are only children, so there's been one beneficiary at each generation in my family. But there are things that I didn't know when my grandmother went into a nursing home about how to pay for that. There are things that I didn't know about Medicare coverage versus Medicaid coverage, what type of term care insurance she had. There are those types of things that a general practitioner may know, but an elder law attorney would be specifically looking out for you in those regards. So even if you just have one beneficiary, that's great, but we would want to make sure you have things to leave to them. And to save those assets, you would need that elder law planning.
Where do advanced directives, living will, and DNR orders fit into all this?
That's a great question too. So advanced directives or living wills, I kind of think of them as one and the same. They are part of the estate planning package that our firm offers. Not only would it involve a will, so where stuff goes after you die, a power of attorney who can act for you while you're still here, but a living will is another document that covers end of life treatment decisions. It's a specific document in and of itself that if you've ever been to a hospital, they probably ask you, do you have an advanced directive or a living will? They say that every time you go into a doctor's appointment. So it's another piece of the puzzle. Are there any other questions? Yes.
What is the average cost of estate planning? And is there a low income budget for some of the families that we work with?
Okay, are you asking just generally?
Yeah, in general.
So I've seen estate planning documents range, I would say around $1,000. It depends on if we're planning for a married couple or just a single person, but we have different payment options. If you need more specialized planning, obviously you would want to pay for that sort of specialty. There are all sorts of options out there, and even if a client meets with us and they have some sort of financial need, then we can talk about payment options. Yes.
I'm going back to the power of attorney. If you made one and signed it in 2000, would it still be legal today, or do you have to update those?
I recommend that you update them, but it doesn't have an expiration date on it. It's not after so many years they go away. I think some folks call that a stale document. It's not necessarily the case, but it would depend on if it has the authority in there that you want. Kentucky law has changed 3 times in the last 5 years on what has to be in a power of attorney. So it's recommended. If you would want an attorney to review it, I'd be happy to do that for you and see if it needs to be updated, but just by length of time, they don't expire. Anybody else? Yes, ma'am.
A secondary question, if one were to choose an estate planning lawyer, just in generalities, if I have my own financial person, why would an elder estate, for a trust ask for my financials?
Why would an attorney?
An elder lawyer ask for my financials. If I come to you and I say, oh, I want a trust made, and I already have my financial planner that takes care of my money, why would you say to me, bring your financials with you when you come for your first appointment?
So we know what to plan for, honestly, because a trust can serve different functions. So I think of trust as an empty bucket. Just because you have a trust doesn't mean that it covers all of your financials. You have to actually put things into a trust. And we would want to help you with that process, so that's why we ask.
I get asked all the time, do I have to go to an attorney, or can I just write my will and have something notarize it? As an attorney, can you speak to why it is more important one way or the other?
You can absolutely write your own will, sign it. There are very specific laws on how that has to be done. And often, if you go about it that way, it makes it more time consuming and expensive on the back end. So once you've already passed away. One of my very first cases, I had to probate or get admitted a will that someone had written on a piece of hospital stationery. Granted, that woman did not have very many other options, but her probate was very time consuming. We had to notify all the family, didn't know who they were. It was also very expensive to do. You have to see who has familiarity with the handwriting and who can vouch for that it was actually you who signed it. There are all of those questions that come into play after you pass away because you're not around to say, yep, that was me who signed it. So I recommend that you meet with a lawyer to prepare your will so all of those requirements can be met and avoid that time-consuming, expensive process later. I think that's it. Thank you all so much. I appreciate your time.